Welcome to the second meeting of the short-term rental task group. Appreciate those who were able to be here the first time, and we've had some new folks join us. Our goal is to have stakeholders from different viewpoints look at our current short-term rental laws and some proposed regulations that are waiting in the council, and see if we can, as a group, think of refinements that will enhance enforcement efforts and make some of the fraudulent attainments of permits less likely to happen. So we appreciate everyone being here, and everyone should have a great little info packet in front of you. I appreciate Roseanne Hayes putting that together. Come on in. And that should include an agenda on top and several pieces of existing state and city legislation, just so we can see what is currently out there on the books, as well as some ordinances that are on hold right now that we may also want to talk about. So first item on the agenda, Councilmember Parker, feel free to come on up if you want to, is welcome and introductions. I've done the welcome. So I'm going to start on this side, and if we can just make a circle and introduce, and let's do the back too, because y'all are important as well. If you'll give your name and sort of what group you represent or what viewpoint, then that would be helpful. So glad you're here.
My name is Grace Bay. I am on the board of NASTRA, Nashville Area Short-Term Rental Association, and that is who I'm here representing.
Great, thank you. Push the little button with push the button with the person on it, and then the green light will come on and you can speak.
Thank you. I'm Amy Crownover, and I am new. And Berkeley asked me to join. I'm the vice president of the Richland West End Neighborhood Association over off of West End, about 300 and 400 homes.
Good. I'm Joey Hargis, the Metro Zoning Administrator, and I oversee staff that enforces the short-term regulations and permits here in Davidson County.
I'm Marilyn Warren. I'm a short-term owner, rental owner in WeHo, and I've been doing that for almost 4.5 years now. So I have a real interest in what's going on in that field in short-term rentals.
I'm Britt DePriest. I'm the Vice President of the Historic Germantown Neighborhood Association, and I'm a broker at Compass Real Estate.
I'm Bill Herbert. I'm the Director of Metro Coverage. I'm Von Elman Broom. I'm the Metro SPRP Chief. I handle enforcement and issuance of permits.
Councilmember Hauser.
I'm Elise Ranzino. I've been the vice president and then interim president of NASTRA, the Nashville Area Short-Term Rental Association, for the past several years. I'm also an owner-occupied host here in Nashville.
My name's Jeff Sheehan. I'm a Hillsborough West End Neighborhood Association member.
Good evening, y'all. I am Sean Parker, Metro Council member for District 5 in East Nashville, and I also am the Metropolitan Council's selected member of the Short-Term Rental Appeals Board.
I'm John Dotson. I'm a member of the Board of Directors of Greater Nashville Realtors, and I'm a broker at Parks.
Great, thank you for giving us context on that. And I would love for, I have my next item is to review last meeting, and then would love to hear just a little bit from codes kind of on where we are, and I'll let y'all decide who will speak to that. So at our last meeting, we kind of got the history of where short-term rental has been from not existing in 2011 to 200 properties when we began making the legislation, which is sort of like letting your puppy play on the couch. And when it was small, it seemed okay, but now it is 5,000 permits, and we didn't know we were going to get a Great Dane. So we're making adjustments as we learn. So we have kind of gone through some of the issues that Codes is dealing with. They reported last time that the biggest issues that they see that need to be worked on are ensuring that when people say they're getting an owner-occupied permit, that they really are an occupant of the property. And that's especially important now because as of January 1st of this year, there are no more new permits to be issued for non-owner occupied short-term rentals in residential single-family, and also no more to be issued for residential multifamily. So all new permits will be in office residential and what else and mixed use, MU, so OR and MU categories. And if you truly are an owner occupant, then there is a pathway to get a new permit, but we want to make sure that those really are the owner occupants because evidence suggests that when the owner is actually on site or is returning soon thereafter, that they make good and sure that their tenants behave. And that's one of the key goals of this group is to eliminate, if we can, or at least minimize the impact on the neighbors. We're shooting for eliminate, but we got to start with reducing at this point. So that's where we left last week, was that everyone had a glimpse of what the existing regulations look like now, and also what the state legislation looks like now, which unfortunately ties our hands with regard to enforcement in several concerning ways. Many of the current owners are grandfathered in under whatever the rules were when they got their permit, and Codes, bless their hearts, now has 10 sets of rules that they have to go back to, depending on when the person got their permit, what rules they have to follow. So one of our goals is to at least try to look at the suggestions that have been made and make them happen all at the same time, so that at least there's only, we're only adding an 11th new set of rules and not 11, 12, 13, and 14, in short succession. So that's another goal that this group has. So that being said, sort of as our background on our last meeting, I would invite Codes folks, if there's just anything you want us to know as we begin our discussion of what changes we make. And there's one more member that I would like. We just finished introduction, so if you'll push your green button and remind us who you are and what group you represent.
Hi, I'm Deborah Volley. I own a short-term rental in East Nashville in District 6, and I also turned 2 short-term rentals back into long-term in Inglewood. So
thank you. Glad you're here. Great. Codes, Joey, you're at the mic, or anyone else can come up. Tell us kind of where things are, and then we'll jump into what changes we might make to make things work better.
Certainly. Thanks, Councilmember Allen. I've passed around to you guys a very rough first draft of an ordinance. And listing in the ordinance, and I'm happy to go through each one, with changes more, we talked about last time akin to not so much affecting the use of the property, because if we get into that state statute, they're going to be grandfathered in the use of the property. These would be changes that we suggested more from an administrative point of view, dealing with the types of information that we require of someone to submit to the Codes Department for their short-term rental permit. Coming up with a sort of a tiered system that some documents carry a little more weight than others. And I'll circle back to these, but kind of rough, 30,000 foot view, some of the items in processing the permits, and then allowing Title VI, the authority for the zoning administrator to curtail water services to properties in instances where we just have violations. We've cited the property owner to court. We've gotten a default judgment. We can't get them to stop continuing to use the property because we can't serve them. That we can, in coordination with the water department, cut the water off for the property, which would curtail activities on that, at least get the attention of the department to cease operating under the belief, if you're out there and you come to Nashville and you're experiencing a good time, but the showers don't work and the toilets don't flush, that you're going to have an issue with the person who rented it to you, which would have the domino effect of stopping those rentals. I have that authority in Title 17 now for zoning violations. when this section moved from Chapter 17, which is zoning code, to Chapter 6, that language did not come with it. So essentially just putting back the authority that the zoning administrator had under Title 17. And then for us, dealing with a little bit of discretion for me as the zoning administrator to determine if there's been a change of ownership that affects the state statute. Because there are instances, I'll give you an example. This week, I got an email from a local attorney whether the property was foreclosed on. Is that a change of ownership? Which I told him, yes, it is under the statute. But you have situations sometimes in previously older owner-occupied or non-owner occupied where an LLC took out the property. And so it was a husband and wife LLC, and they wanted to refinance and take advantage of the lower interest rates, and the lender would not they wouldn't do the note on an LLC, but they'd do it to the individual. So they filed the paperwork at the deed and converted it from the LLC back to the husband and wife. Did the refinance and then immediately put it back in the LLC's name. To me, that's not really a change of ownership. It's still the same parties, same entities. At least there's some flexibility in there to allow us to say, okay, that's really not a change of ownership. It's not a transfer of sale. But this is I couldn't figure out in Word to do the pretty draft watermark, but this is a first stab at that. And if there were other items, this committee thought, things are in discussion with Mac, and I'll turn my seat over to Mac here in a second. Any other items that you thought I left on the agenda here that needed to be covered, but with the focus more on permit processing rather than land use. So that's sort of where we're at with this. And if you didn't get one, I'll be happy to. I'll
Gotcha.
send one over.
Have people gotten a copy of that? Yeah, it seems like it's made. Some copy is made. It's from John. You look like maybe it hasn't. Yes. Is there one
I'll be
more?
happy.
Okay.
Yes, ma'am.
Here we go. There you go. Sorry you had to sit through all that without that. We appreciate you drafting that up, and those are big things that we talked about. Are there questions on those? And then I've got a couple of comments as well. Mr. Dotson.
I have one quick question, and it has to do with the LLC ownership. If there's a change in the membership of the LLC still continues to own it, but there's a change in the membership, does that constitute a change in ownership?
It would not. The membership could change within the LLC. The entity itself, as long as it survived and continued to own the property, it wouldn't be, even though the membership may rotate throughout as members of the LLC, that would not be deemed a change of ownership. And that's been the direction we've gotten from Metro Legal, a defensible position in court that we don't believe we could win an argument that the membership changing is a change of ownership within the LLC.
And this is kind of a tangent to that. If there's a divorce and in the divorce decree, the wife gets to keep the property, does that constitute a change in ownership?
Actually, if you could come up and address that. We've encountered that situation, obviously. With 5,000 permits, that's bound to have come up before. I'll let Matt cover how.
Why don't you come sit right here? You have an extra seat.
Actually, the way that we handle that now is if before a divorce or a marriage, if the person that retains the property's name was on the deed before and after, then it does not constitute a change in ownership.
And I know I've just had this question come up this week. So if she assumes there's a divorce, she assumes her maiden name. Is that a change in ownership?
That is not one that we have encountered, but it also would depend upon whether it was owner-occupied or not owner-occupied. First off, if it's owner-occupied, it can only be issued to a natural person. It would still be the same natural person, so my instinct is that would not constitute an ownership change. But quite frankly, that's not a situation we've encountered.
Yeah, we've not run into it, but from the standpoint, how would we handle it? We wouldn't revoke a permit over reverting back to a maiden name.
Can I add to that? I mean, this is all good for people who have followed the rules and been good neighbors and not been disruptive. One of the challenges that we've had is the standard that the state has now set for revoking a permit. We started with 3 strikes, you're out, which sounded great. If somebody, you know, has 3 loud parties 3 weekends in a row, then they're done and we take their permit away and that's the end of it. And state law was passed that now raised the bar that we have to prove in 3 separate courts, appealing all the way to the Supreme Court, if I understand that correctly. Only then can we truly revoke that permit by state law at this point, which so far, if I understand, has not happened successfully. Is that a true statement?
That is a true statement. The standard which the state has imposed on us is as Director Herbert talked about, an extremely high burden, almost
And so
unable to overcome it.
my question is, if somebody has been a bad actor and they change names or something like that, do we have the flexibility to say, this is a change in ownership and you lose your permit? I mean, can we keep things flexible enough that at least gives us a tool we could use in those cases where we need it?
I don't think in the instance of a divorce or anything, I don't think even given those circumstances that the analysis is any different for us. You know, we do have some language in the building code in Chapter 16 that talks about, and Bill, this may be something you may want to add to, but Chapter 16, this is in the building code, it discusses dealing with revocations of permits. In addition to any fine imposed for a violation of this title, permits granted under the provision of this title may be revoked by the director. No new permit shall be issued to a person guilty of violating any of this title under the work done in violation of the building code title until at such time it's been corrected to the satisfaction of the codes director. So, I mean, there's a little bit of language there that we've invoked for bad actors, but if you've got any, Bill,
And I think that's kind of a 2-part question. You know, are there ever circumstances where we can use some other technicality to take a permit away where this incredibly high bar doesn't permit us to, but they've met the 3 strikes and they ought to be out? Or we had talked about multiple offenders trying to get another permit on another piece of property, which is a separate but related question. So can you address both of those?
Could I go back to the original question about if we've just got an inherently bad actor that just doesn't comply? Generally speaking, we will already have a judgment against that person, and then it's a matter of enforcement of the judgment.
Gotcha.
I really feel pretty strongly that having the ability to discontinue water service is going to be a really strong tool to get that done. I've taken the next step and talked to Scott Potter, the director of the water department, and he is in complete support.
Great.
I've also looked into the authority that the water department has to curtail service, and they obviously already have that, but nothing that specifically addresses a situation like this. So I would suggest that we further, when we get into any amendments or the creation of the language for this bill, that allow us to insert some language that's applicable into the water department's authorities, so that if we make the request to curtail the service, that they then have the authority to discontinue the service.
Is that legislation or just in their policy manual?
It's legislation.
Okay. Okay.
Could I ask a question about that?
Yes.
You said that you oftentimes already have a judgment against a property. What types of things would cause you to have a judgment against a property? How does that process work?
Operating without a permit is probably the single biggest one, wouldn't you say, Mac?
Definitely in the past that was the main driver, but today the more common case would be an expired permit where they continue to operate, and now they are given a notice of violation. If they fail to comply within the remedial time period, then there's a court case brought against them. And that is an instance whereby if you have a bad actor, you can't permanently prevent them from having a permit, but you certainly can give them an injunction. Depending upon when they obtain their permit, it can be a 1-year or a 3-year injunction, but that's a pretty good period of time.
So when we talk about a bad actor, we're talking about something that's more like permit related, the technicality of the permit, and not so much things going on at the house or anything like that, correct?
That's correct. Because
Okay.
things going on at the house under the state law is very difficult for us to pursue.
Okay, thank you.
If I can follow up on that, in the language of the regulation, there is a grace period allowed for properties that do not have any violations on record against them, and there is no grace period for properties that do have violations documented against them. And I'm not entirely sure what that documented against them means now, since we have the state bar. But is that something that codes follows at this point?
It's definitely in the ordinance, and it's without referencing it directly, I believe it's 3 within a year, and I believe what would constitute that would just be a definite violation of the short-term rental ordinance, and it's left to the discretion of the zoning administrator as to whether or not to renew the permit. However, it's my understanding that the state laws have preceded that.
Okay.
That language is in the ordinance, but I think that it was made of non-effect by the state law.
And I'm seeing Bill nod.
Yes, I agree.
Okay, I am searching for tools that give us more ways to stop the operation of properties that repeatedly bother neighbors, which more often than anything is noise. Sometimes is parking, sometimes is throwing up in their front yard or whatever. And I guess what I'm hearing you say is the curtailing of services is probably our most effective tool. That tends to happen only in judgments about operating without permits.
Right, or other instances where Mac and his team have filed a warrant against the property, and we have a judgment against the property, and the property owner, in spite of the judgment, will not comply with the court order and continues to rent.
Okay.
Yeah.
Okay, and that's clearly a problem we need to solve, so I appreciate that.
If
I
could
feel a
bring-
question down there, yeah.
Yeah, if this is not the right time to talk about this, cut me off. But at HGN, the complaints that we hear from neighbors are always related to 2 things. The most predominant one is noise. The second one is trash. That's probably 90% of the comments that we hear from neighbors. And part of the frustration that neighbors have with this is when those violations occur, it's then their problem to deal with. You know, they call the police if it's noise, and they wait 30, 45 minutes on hold, and maybe the police come out the next day or a few hours later or something like that, and there's no relief. So I just wonder, is there a way to solve it, or not solve it, but lessen the impact a little bit? You know, if someone's staying at a hotel, there's a front desk. If there's a problem, they call the front desk. I would think in this case, that role could be played by the property manager. The Nastra people here can answer, do most non-owner occupied short-term rentals, are they managed by a professional property manager?
I don't know if I can speak to the percentage, but
Yeah.
probably a good majority of them are.
Right.
There's plenty of self-managing non-owner occupied that live locally as well.
So, okay, but they would live locally. I just wonder if there's a way that we could communicate with neighbors, figure out a radius or a number of neighbors from these short-term rentals. This is the front desk. When there's a problem, you call this person. But that person would then have to be on call, whether it's the owner or the property manager.
And that's already
So,
required.
I was going to say, currently that's required. And host compliance is supposed to, if someone calls the host compliance line, they immediately call the person whose number is on file with the permit, which is usually the property, whoever is the property manager, either the owner or the property manager.
Right.
And the property manager has to answer or respond within like 20 minutes of that call. And they have to be available 24 hours a day.
So host compliance is through the city, is that
Yes.
correct?
Yeah.
And that's like a
The city-
catch-all number that someone can call.
Yeah, the city paid $1 million, I think, for host compliance to manage that.
You guys are one step ahead of me on that one then.
And
Good.
so I'm a neighbor. I'm new. I just moved in. I hear this party going on next door, and I know it's a short-term rental. Where do I look to find that number?
If you Google Metro Codes short-term rental, it pops right up. And host compliance, the line is right there. Have a complaint? Call host compliance. It's
Okay.
like right on the front.
Well, and I think Hub National also will get you there, won't it? Yeah.
Yeah.
Yeah,
It
so
gets,
if you,
it gets you there.
yeah,
Everybody's being trained to go to HUD.
Yeah.
I just asked that.
there's, in fact, I talked to the mayor's office yesterday about that, and if you do contact the hub for that,
Yeah.
they will then refer your hub complaint to host compliance.
24/7.
Right.
Okay.
They don't have the number on the HUD site.
I think that, do they give you, do you know, Mac, I think they leave a mess, they give you, they give you, there's a list you go through, and for short-term rental complaint,
I must confess that since the website has been revamped, I have not checked it, but I know in the past it was definitely there. In fact, it was the only number actually available on the hotline, so we would get some calls for other issues. But nonetheless, we got all the short-term rental ones. There was, the number was posted there.
but you're right, it is front and center on our website.
And another part of that conversation we had, you may recall, written in the last one, was that there is a map that has the locations of short-term rentals, so you could go to that map, and if you had a problem, you could find the name and number of that person that's you have to put on the application when you get the short-term rental permit. So it's,
So,
if I was having a big problem, I'd be calling both the guest compliance and also try to find that number myself.
It's on HUD. It's on HUD, yeah. I mean, you have to click a couple times, but it gets you to call the host compliance to file a complaint.
Great. Okay. I think the more places we can make that easy to find.
If I could ask Director Herbert, so I wasn't aware of the requirement that person. I wasn't aware of the exact requirements of like how responsive that person had to be, how available that person had to be. What happens if the person doesn't respond? The responsible party for a Airbnb. Are we able to issue one of the 3 strikes in that case? I would imagine no, because it's not a generally applicable law unrelated to Airbnb. So what happens if they don't answer, if they just kind of are a name and maybe a number that goes to, a Google Voice number that goes to voicemail?
Councilmember Parker, that is a fantastic question. Honestly, I don't know that I can answer it, to tell you the truth. Mac, do you know, or Joey?
Yes, we have encountered this situation. It's not a frequent happening, but when we have encountered it, and a lot of times we've had a switch in the management company and it has not been updated, or the responsible party that's not a management company has been changed and it has not been updated. Now, in the ordinance, any complaint that we get, the ordinance says that we are to notify them either by email or by letter. And I personally like the letter, and in many cases, if we have an email that is current, we'll do both. But I have examined this with legal, and even though we can cite them on the section of the ordinance, it was their opinion that we could not carry it to the warrant level, and it definitely would not constitute a strike.
Mm-hmm.
It's just basically a requirement to update your information.
So can we do better than that? I mean,
Can I ask a question?
Yeah.
I was under the impression that it would be a strike if they didn't respond right away. So you're saying it's not necessarily.
Unfortunately, in February of 2018, the council passed a law that had some real teeth, and for a few months we were delighted. However, the state law on May the 5th of 2018 basically came in and gutted that. And it basically, I mean, the strike language is still in the ordinance, but it's really of none effect. And the reason for that is the state law says that it cannot be just strictly a short-term rental ordinance that applies. It has to be a law of general applicability, which means it has to apply to any property in Davidson County. So the only thing that you're really looking at is maybe a drunken disorderly, maybe a noise violation that violates the noise ordinance that's in effect countywide. It has to be something of a general nature, which in essence, and it has to be carried to the full extent of the due process that the individual has. And so the chances of actually getting 3 of those in a 12-month period is virtually nil.
I've got a question.
Yes.
Is there any leverage against these management people? I mean,
Mr. Herbert, is there any leverage?
Mac, thoughts?
Yes, I'll tell you. We really like it when a management company is actually in charge of the property, particularly the non-owner occupied properties, because I'll be quite honest with you, initially it was like everything, it evolved with the short-term rentals, but there are some extremely responsible short-term rental management companies that they do some other things, but they do virtually that and that alone, and they're good at it. They stay on top of the current iteration of the ordinance, and they do everything they can to comply, because if they don't and their client gets a warrant or their client gets their permit canceled or it expires, it's a bad mark on their reputation. I'll tell you, news travels fast and it costs them a lot of money. So they're in business to be on top of this, and there's a lot of them that have really become quite good, and so that's an advantage. And there are a few small-time operators that are irresponsible and that just fly by the seat of their pants. But the majority of them are established management companies that do a good job. They're responsible.
also, do the management companies actually refer back to the people who actually were on the premises at the time of this?
Do you mean, do they contact them when they receive a complaint?
Well, yes, I mean.
Oh, absolutely.
Like an Airbnb, if you do something like that, you'll never get another booking from Airbnb again. But, so how does, is there?
In the rental contracts for a lot of these properties, now it varies property by property, but in rental contracts for a lot of these properties, if there's a stipulation in the contract to which the renter signs, that if there is a noise complaint or if there's any type of arrest or any type of incident of that nature, they fine them a big amount. I've seen it range from $175 to $500, and they've got their credit card, and they make sure that limit will withstand that, and they'll charge them, I'm sure of that, because a lot of these companies that have non-owner occupied permits own the property and manage several of them. They have numerous non-owner occupied permits, and they when we get with them, and that's one thing that is very important. It's the broken window principle. If you stay on top of the little stuff, then the big stuff, they know you're watching. The big stuff doesn't happen. So, and with a limited enforcement team, it's difficult for us to do that, but we're pretty good at it. But the thing about it is that when they get numerous complaints for a property for noise and issues of that nature, and we're sending in notice after notice after notice, even though it doesn't have a lot of teeth and they know we're watching, they've installed noise detection equipment, and it notifies them even if there's not a complaint filed and there's nothing through the host hotline. They pick up on it and they address it. I know that to be a fact. Now, how widespread that is, I cannot gauge, but I do know a lot of these not owner-occupied properties with these management companies have installed this.
Well, I just wanted to say that I know people that come to my Airbnb, it's an Airbnb, live in fear of a bad review. And I don't know whether this happens anywhere else, you know, whether the management companies have this leverage. So, I mean.
So even though they're managed by a property management company, most of the time the booking is still through Airbnb or VRBO or Booking.com at a site that is getting a rating for the guest as well as, yeah.
Okay, see,
I would say 99%
I'm in my little
of the
world.
time.
I don't know what happens
Yeah.
elsewhere, but this rating the hostess and rating the guest is a real tool. So it makes a difference to the customers. They live in fear of you're not liking what they did there while they were there.
So we have no control of that, but it's in our favor that it exists, it
Yes.
sounds like.
I mean, it's.
Could I get
it's a-
clarification on,
Yes, Jeff.
on one point? If we have someone who has an owner-occupied permit, and that owner is in fact not occupying, what are the consequences there? Is that a pathway to identifying a clear bad actor and eliminating effectively a permit because the permit is for owner-occupied and you have, in fact, a non-owner-occupied space?
That's an issue that we see a lot, and I know that Matt can speak to it in great detail, but here's the overview of it. Proving where somebody permanently resides is insanely difficult. So you and the neighbors may very well know this person does not live there. He's never there. For us to then turn around and prove that in court is very, very difficult, because they'll turn around and say, well, you know, I've got my driver's license here, my voter registration's here. You know that he's not living there, but how do we prove that in court? And we lose the overwhelming majority of those cases that we attempt. We'll occasionally get some that the neighbors feel very, very strongly about. And I know, Mac, you can jump in here, but neighbors will say, we'll come and testify that he doesn't live there. We nevertheless lose the overwhelming majority because we cannot definitively prove where somebody calls their permanent residence.
So I can understand that being a challenge on the margins. One of the things that I think is coming up fairly frequently is that unless neighbors are livid, that there are a lot of steps. I know that we can say, well, you go to the Board of Zoning and you look that up, and if you put in the word zoning and codes, you get there. But I was doing my homework for this committee, and I had those words, and it took me 2 or 3 times to find it. It wasn't 9 times, and I got there. And as I did it, I found that one of the non-owner occupied short-term rentals that I was familiar with and was occasionally bothered by, but not deeply bothered by, it turns out it was not owner-occupied at all, but its permit was owner-occupied. And I got a letter that was like the sort of form letter that goes out that doesn't actually provide any information about what the requirements are. It gives an address, and so you can know something's happening. But I can promise that if that letter said, I am applying for an owner-occupied short-term, and the number of guests that could be permitted by the permit I am seeking is X, and if there are any problems, there is a host number that is available at website, and that this other Metro line that's available at phone number, that I think I would have looked at things differently, because I think neighbors recognize that these kinds of housing options, these kind of short-term housing options, can be done really responsibly. But if someone is lying to me and lying to the government about what's going on there, I think it's the reverse of that broken window principle, that they are less likely to get the benefit of the doubt. And I do think that would be helpful, because it would not just apply and not just educate the neighbors about what to do with the new permits that are coming out, but it would also help to identify what do we do to build a record around other the number is going to be the same. The short-term, long-term might be different, although going forward, not so much. The number of guests that would be available is going to be different, but it would still spark some knowledge that it's there. And when I went and looked at the website and was able to go through the map, it was lovely and manageable once I got there. But it would also help to educate, to make sure that people know who to call and how to do this and where to get there. And do it without anything that would be attacking a grandfathered permit, but simply provide a better baseline understanding for community members, that particularly in areas where there are more of these applications and more of these permits coming out.
Right, and that's a really good point. And that's one thing that we also suggested, and I know that at the last meeting, Mr. Hargis went into this in a little bit more detail, and it was allow the zoning administrator, when neighbors are contacted with these notices, allow the neighbors the opportunity to send information to Mr. Hargis as the zoning administrator to review, because now currently he can't, we must issue the permit if they meet the criteria. But if we allow him to consider some statements of neighbors, then that would I think greatly assist with that. And if we beef up the requirements for proving that you in fact reside there in the first place during the application process, that those two things could help a lot with that situation.
And thanks for bringing that. And I'll point out that the document that y'all have been passed out has now the requirement for 5 documents instead of 2. Is that all we require now? And it's a tiered requirement so that you have to choose from some things that are really hard to fake, you know, for at least 1 or 2 of them. And Joey, did you get the renewal in here, or is that something we talked about saying, and every year when you renew?
In this draft, I don't have that.
But you can do that.
Yeah, I certainly can. We've got some language in there now on renewals that says you must provide the documents required in Section 3 of the code. And when you read Section 3, it's the application stage. So I think we can tweak that a little bit to just say, you know, when we add the requirement for this sort of 2-tiered worth of documents, we change the code to refer, you need to submit these annually. Now what we get is an affidavit saying all the documents I've submitted initially, nothing's changed. I'm signing it, and you know, but requiring those documents up front and annually as they do it. And to the extent of as Mr. Herbert talked about, you know, we're inclined, you know, we have to issue a permit. I have denied some permits in recent times where they've shown me I live here, and I don't want to talk specifically about a case because I've denied a permit. I've provided this person an opportunity to appeal to the short-term rental board. They've not filed an appeal yet. So, but let me give you the hypothetical situation is all the documents I have for this location, insurance for the property in question, tax records from us showing the bills going to another county, those types of things. To me, I just the weight of the evidence. There's more evidence here to say you live in Sumner County. You don't live at the property at all. I've denied the permit. Whereas in times past, it was just, oh, you check the box, here's your permit, and we didn't have that input. But on the same token, I want to protect the applicant's rights too. I don't want to take every complaint from a neighbor as is gospel. You know, hey, he doesn't live there. We talked about in the first one, there's no requirement that they be present when they're saying. There's no limit to the number of days you can rent a owner-occupied. They can rent it 365 days a year. So there's no distinction from the standpoint of how many times can I rent my house, non-owner versus owner. Until we have that distinction, you know, there's not a requirement. So you get sort of this gray area: do they live there or not? If an owner, as part of this regulation, affidavits from neighbors within the notice area regarding the residency, it's not just, I don't believe he lives here. I don't believe he lives here, and here's some proof, Mr. Argus. I mean, it's not just a statement, I don't think they live there. I think we need a lot more to consider denying a permit. But in this instance, it was like 10 documents saying Sumner County and 2 saying here. You know, I was like, no way I'm issuing this. Go to the
So
appeals board.
you've written that in as a possible change.
The affidavits from neighbors there is in there, at least to give a period. But I wanted to provide a window for neighbors to submit evidence that, hey, they don't live here.
Gotcha. Do you
But
need to
not
refer
bothered.
to other government documents that you have access to? Does that need to be included in here?
Perhaps there is. The two-tiered section there in section 1, we looked at driver's licenses or any other valid state
Well, for
issue.
example, what you just mentioned about things that you looked at that were from another county, those were not things they submitted to you. Those were things you found.
Those are
with the-
things that we had in our records anyway from the
Gotcha.
tax assessor's office or.
So can you refer to those as something that you can consider in whether to deny or
Sure,
issue the permit?
if that's necessary to list out, we'd be happy to
I mean,
amend.
that's a lawyer question. Does having it listed out give you more authority to do that?
I mean, from the standpoint of, we're into more business process of how does code operate these. I don't know necessarily need to quantify
Okay.
each item in that. It's just kind of understand from the standpoint of, hey, we're looking at other things other than just what they put on the paper of, yeah, here's where I
Okay.
live. We do look at
If
it.
the lawyers are good with the language that's there, I'm not going to argue with that.
Yeah, I think we're fine, because what we're doing is just looking at records that are publicly available anyway. We just have easier access to them.
And so that's cleared under any documentation
Yes.
that the owner does not permanently reside. Okay,
It is.
that sounds great. Mac?
A couple of quick points. First off, until this point, and this is being considered, and it's going to be a very useful tool. We'll probably want to avoid too much specificity because we want to have it where it's the zoning administrator's discretion. And prior to this, the ordinance only called for it to be a notification. We would have people contact us and say things. We didn't have a mechanism or a vehicle through which those complaints were usable in the permitting process. And that's been a focus of ours in these changes, is to make sure that we get that input and that it is documented and considered before the permit is issued. Because a big push about this, and I stated this at the last meeting and I'll reiterate it, is that with the change in the limitation of not owner-occupied permits excluded from residential areas as of January 1st, the potential for more people to attempt to obtain owner-occupied permits fraudulently, we saw that as an issue that we wanted to address before it became a big problem. And so this is a lot of the conversation that we're having revolves around that, and it's very important, because if you take care of it in the permitting process and the permit is never issued, then you don't have all that time tied up in investigations and court.
That's great.
Berkeley, if I can just speak a little bit to
Certainly.
the process. When I get these documents and Mac and the staff bring to me, like, Joey, here's what we've got, you know, I will write a letter to the applicant saying, I'm you know, or call them, hey, I'm not inclined to issue this based on, here's what I'm looking at, can you provide? I'm going to give them an opportunity to supplement their submittal, you know, oh, yeah, let me explain that, you know, Dad died and I wasn't able to, whatever the reason is, but at least some opportunity, and I do want to be fair to the applicants in that, where it's not a hard set, oh, you don't have the 3 things, denied, you know. But any appeal of my decision whether to issue it or not issue it, for that matter, you know, if I issue a permit and the neighbors don't believe it should be issued, you can appeal that to the short-term rental board. So there's an appeal either direction. We haven't had many of those, but you could appeal the zoning administrator's issuance of a permit to the short-term rental board, believing it should not have been issued.
Would that carry the same fee as?
Yes.
Okay, we
It
just
would.
raised that bar, so I
Yes.
do want to make note of that.
The fee now is $421 for the appeal. The appeals were $0.
Crowdsource that if you've got a group of neighbors, man.
And that's something I would also like to emphasize, is that it's a recent development that we have a dedicated short-term rental appeal board, and it's very, very good. It's a wonderful route as opposed to going through the courts.
If
Or
I
the
may,
BZA.
I'm sorry, there was a couple of comments I wanted to make. You know, I think that the things we're talking about here with the strengthening our owner occupancy awareness when people come in for permits, I think that's great. And I also think, as the gentleman to my left, whose name I don't remember, I'm sorry, coupling that with some changes to the neighboring letter that maybe just in plain Jane language that anybody can look at and say, dear neighbor, I'm requesting a permit. I'm eligible for this permit because I reside at this home. It is my residence, etc. I think that might help, get some of that feedback from neighbors early on in the process. But I did want to circle back, now that we have Mr. Hargis back with us, to the transfer of ownership question and LLCs specifically. So, I've watched for years, the BZA and the complicated people that are doing estate planning or, divorces or anything like that. And it's certainly not the spirit or the intent of any regulation to say, oh my goodness, well, you put this in a trust so that your kids, and now you can't have it any like that. That doesn't make sense just on the face of it. But sort of the other side of that coin is, to what extent are people placing properties in LLCs strictly to gain durability of transfership. And so that's something that I don't know how we can look at that, but so you see, I'm not doing this because it's a estate planning or refi. It's oh, I see a a code change coming on the horizon. Say I have a property in an RM district 6 months ago. Well, I'm gonna go switch that over to LLC so that I can sell that permit with that property. Yes, I'm selling the LLC now, but essentially the whole point of that would be to, establish durability of transfership. Do we have any way that we can sort of hedge against that?
Yeah, well, we do currently. That, if I go from Joey's property to Joey's LLC, it's a transfer under
But
statute.
within an LLC, if Joey sells it to Sean, it doesn't. And Bill, you've been with me through this whole odyssey. I believe when we started this, only a natural person could own any kind of short-term rental, owner occupied or not. And somewhere along the line, I think when we moved things to 2 separate paragraphs, we left the language about a natural owner in the owner occupied and then allowed for LLCs to own the non-owner occupied. Is there anything that prevents us, granted it won't apply to all the existing ones, but is there anything that prevents us from adding that language about only natural owners can own a non-owner occupied in that section?
I don't think there's anything that prevents you, other than everything that's already there is already grandfathered.
Right.
So it would be only for new ones moving forward.
Berkeley Allen, I seem to remember when that came up, 2017, 2018, that for some reason, maybe legal had said that was not something that would be able to be upheld in court because you can't control if someone wants to buy it with an LLC. I think that was the...
Let's ask the lawyers.
If I may be interacting that.
The direction we've gotten from legal is that the underlying, I want to circle back to Sean's question. The LLC owns the property. The LLC still owns the property, that entity. The membership has changed within the LLC. Legal's told us that's not a transfer because that's, to your point, we can't win that argument.
But the other question is, can we say from this point forward, LLCs are not eligible? You have to be a natural person.
For owner occupied, I
For
think you can.
non-owner occupied.
Well, I think you can, but what you'll end up is grandfathering all the ones that have.
Who
And
are,
they'll be subject to the statute.
we can't do anything to them
Can't do
anyway.
anything. Going forward, I think you can do that, But back to Sean's question is, Sean owns the property, he wants to put that property into an LLC, and I currently have an owner-occupied permit, that's a transfer. That change from Sean to Sean's LLC is a transfer on the statute, and that permit's no longer valid.
But say, again, the example, if it was 6 months ago in an RM zone, that LLC could go and apply for an RM permit, seeing sort of this change on the horizon to where residential can no longer do non-owner occupied.
Right.
But if they've put it in that vehicle of that LLC, they could.
At the time the permit was issued, it was issued to the LLC. That membership can change inside that LLC.
Yes, that's just something I wanted to clarify.
If they had the foresight to do that, then they're probably going to be okay as long as they keep all of their documentation correct. But the number of those, given the time limit, once they realized that this date was coming and the short window for them to do that, it's going to limit that. It's going to limit that number I mean, they only had so much time to figure it out and do it.
That was something I wanted to ask about, was just, and you know, I know this is kind of asking for data that we didn't ask for ahead of the meeting, but just subjectively or qualitatively, did a lot of those come through in the 18 months or so before January 1st?
Yeah, well, we had a lot. In fact, the ordinance was passed 2 years earlier.
So 24 months.
And then it was delayed for that very reason, because Mr. Herbert had so many projects come to him and say, this is our business plan. We are heavily invested. And so he went to the council and said, we have to address this. And so that was the outcome. The majority of them were probably already in the pipeline, and now toward the end we had some procrastinators. We got jammed there the last couple of months, but it's not an inordinate number. Now, we did process approximately, well, somewhere just above 300 permits for December, but they were not all non-owner occupied permits. A vast number of them were, but you know, it's not going into the thousands.
Okay. And Sean, to emphasize Mac's point, is just this week I've had conversations with two, is they applied for the non-owner occupied in RM. So they made their application to Mac's group, but they don't have their final UNO. We're not issuing, they're done. They had to have it. They're rare instances where that's not the case, but they're, I mean, less than probably the number on my hand. But if you don't have a final UNO and you didn't apply before December 30th, you're completely out of luck.
Because I'm getting calls from people about, we have some areas that are zoned RM and we're maybe underdeveloped in my district, and so I'm getting a lot of emails and calls from constituents saying like, hey, I'm not seeing a UNO in the system. Does that mean that we're, you know, protected from having these 4 units right next to us? And I've been telling them that yes, that's the case. If they don't have a UNO by December 31st, then they're almost certainly not going to be eligible for non-owner investor-owned permits, basically.
So there are rare examples where that's not the case. Yeah, I had one that couldn't get a final UNO because the windows that he's putting in this thing are sitting out in a container out in the Pacific Ocean. You know, that, it's unreasonable for us to not issue his permit. We've given him temporary occupancy. You can live in it, just the specific plan. This is in one of those zones that required a certain amount of windows per street front. It's unreasonable for us to not issue the permit. You know, so there may be the rare instances where I'm going to issue that permit.
Got it.
But,
And
Thank you.
I'm going to jump in just because we're getting close to 7 and we're not quite through our agenda. But this has been a good discussion, and what we have talked about a lot is refining the mechanisms for approving owner occupancy, and Mr. Hargis has given us a document that is well on the way to doing that piece of it, and enforcement of the out-of-towners who we can't successfully summon is the ability to curtail services, and that's in this document as well, which we appreciate. And Max sent me something earlier that I think there might be a copy of, that shows language from other parts of Section 17 where we specifically say, if you have violations on other pieces of property, we're not going to move forward with this. And we can use that language if someone comes in to get a permit and they have multiple other properties with multiple other problems, then we can give them the authority not to give them that permit. I don't think that language has been written or added to this. And Joey, I see you tilting your head. Is that something we can do using that language that I think Mac found and sent?
yeah,
That's
that's the language in the building code that I read a
Right.
little bit earlier.
There
I
you
don't
go.
have that in this.
But it can be.
In this draft, I believe you can ask that.
Okay.
so.
I mean, those are things we talked about at our last meeting wanting to get done, and we are well on the way to having those, and some of you have, some of those things are in this document that we have. And we also talked about the notification template, and I think we've gotten some really great suggestions on that, which I saw Mac writing down. I would love to assign 1 or 2 people to help Mr. McBroom revise that draft and bring it to us. It looks like to me like we will probably meet at least one more time. We'll get to that in a second. But I would love to have I see a hand raised there, 2 hands over there. That's your team. So if y'all can update that template to include, and I'll run back through the information that I saw. We wanted to mention,
Hey, Berkeley, just real quick on that. If that's something that is not currently in the law saying that the language has to be that is something we could implement soon with outside of this, just as a business practice
Right.
policy. We can update our
do
notice
we need to
requirement.
add into the law that you have to use that template, or do we want to? Bill says we don't. Okay. All right, so
Yeah,
we can make that change on the website as
We-
soon as
we
we're
can
happy
just-
with it.
We can just require that administratively.
Okay, great. So if y'all can work, you three can work on that language. That's Jeff and Deborah. Okay. All right, y'all are assigned that. Great. And then things that we haven't drafted.
I think
but
that was Elise Runcino.
I'm sorry, I wrote it down wrong. Elise, thank you. Sorry. You're unvolunteered. Thank you. Thank you, Deborah. Sorry about that. We had talked about ways to deal with complaints from multifamily properties. There are some RM properties that have 8 different owners for 8 different condos all right next to each other. And so if there's a party every weekend that is a real nuisance to the neighbors, there is currently no mechanism for, again, lodging a noise complaint against an owner, because there's no way to know which of those 8 the loud party is coming from. We're not going to solve that one tonight, but put that on your list of things to scratch your head on. And I don't know if that's saying, that we provide the neighbors with the names of all 8 management companies, and they call all 8 management companies every weekend until they all get tired of that or something. But anyway, we're looking for solutions for neighbors here. There are, a limited number of problems that we want to make better. So ponder that one. I asked last week about, do we need a guest registry? And I think the answer I heard was not really, that if there's an issue like a crime where we really need it, Airbnb, the platforms have that, and theoretically we'd have some way to go. So I'm going to scratch that one from it unless other people feel strongly about that one. So I'm saying no. And then some new items to think about. Okay, someone, Marilyn, it may have been you, mentioned that there is a requirement not to advertise the whole house for rent if you're owner occupied. Again, depending on when you got your permit. And so the codes department would have to know that. This is one of those things that is like advertising for more occupants than you can have. It's a violation of our code, but state law says it's not a violation of general stuff. So do we have a remedy for that, or is that something we want to tackle? And again, I think what I'm saying here is these are issues I would love for y'all homework. This is your homework assignment. Ponder these, and let's plan on having one last discussion about these.
Could you clarify exactly what you mean about the excess occupancy?
Yeah, in the past, we had said it is illegal for you to say I can hold 20 people because our limit is 12.
It still is.
It is still illegal, and for a brief moment there, all we had to do was have a screenshot of that, and that was a documented violation that would be one of our 3 strikes.
No, it was actually grounds for revocation directly, just one.
Yeah.
But no longer with
But
state
no
law.
longer.
However, we still do prosecute that.
Okay.
Yes, and we go to court on that
Great.
if they don't comply.
Okay, so that's useful. And so my question is, can we also use saying, whole home available, come stay in this home. Nobody will be there if it's owner occupied and they got their permit after we passed that piece of the legislation.
We most definitely prosecute that as well.
Okay, we can. So that's already there and taken care of, and we don't need to make any changes, is what you're saying. Done. Okay, cool. Okay, now this is important.
Can I ask a question?
Yes.
So in our neighborhood, we have several homes that have carriage houses. So I think we have an instance where somebody does rent out the whole home, the main home, and the owner just relocates for the weekend to the carriage house. So technically, the whole home is.
But not the whole lot.
Especially with the new, my understanding of the new density movement to allow a second dwelling, that gets a little confusing.
So, if I may jump in, I believe that in the whole home listing legislation, we did carve out specifically that the accessory unit could still be listed as a whole unit, but I don't think it applies to the main house. And then also Councilmember Allen's short-term rental overlay. That particular thing does not even permit Airbnb activity in those new units that would be constructed under that overlay. I just wanted to jump in there, but Mr. McBroom, it seemed like you were addressing him, and I jumped in, so I didn't want to.
Gotcha.
Well, it boils down to if they have a permit issued after the language in the ordinance changed to you cannot advertise the whole home on an owner-occupied permit, they cannot do it, and we'll prosecute it. If they have a permit issued prior to that, they're free to do so.
On that new legislation that passed, I'm curious if, when, and how applicants for new owner-occupied permits are even being told that information. Because I pass that info along numerous times every week, and I'm told that I have it wrong because they talked to someone at permits at codes, and they were told they could rent out their whole house. So there's a miscommunication somewhere, and I think then people are slipping through advertising whole homes, and then we're waiting for enforcement rather than cutting them off on the front end by figuring out that that's the plan.
No, the permitting process is very specific, and the number of occupants is based upon the number of bedrooms. And the maximum number of bedrooms is 4. You can have 4 in an owner-occupied permit. And you...
Well, I'm not talking about the occupancy limit. It's that the new legislation that just passed last year saying owner-occupied permits can't be listed as whole home spaces.
They cannot be advertised as whole home spaces. But if you're permitted for 4 bedrooms, and you can be for an owner-occupied permit, then you can advertise 4 bedrooms. You can't advertise
You
whole
can't
home.
have 5 bedrooms
No,
in
you
a
can't.
house.
You can't have anything
And
over
so
4.
if you have 4 bedrooms and you can't advertise the whole house, how can you advertise all 4 bedrooms?
It's
You
legal
can't
to
advertise the kitchen, I guess.
It's legal for you to advertise the number of bedrooms that your permit allows.
It's more about the way it gets categorized on the listing sites as either a shared space or a private entire home rental.
Now,
That's the difference.
Shared spaces are not approved sleeping rooms, and we don't allow that either. When we see that, we send notices of violation on it, because you can have 3 bedrooms in a shared space. If you're permitted for 3 bedrooms, I'm sorry, 3 bedrooms, no shared space.
So I do think that Elise is referring to, if you're a person looking for lodging on the app, it'll either say, oh, this is a room in someone's home, then they're going to be present, or it'll say you have the whole unit to yourself. So I think that's what the industry folks refer to as shared space, is a unit where the operator is on site.
So we need to check and see if our website is, because there's a section in there that informs you as an applicant what your requirements are. So we need to, here's another homework assignment, to look at the website and see if it makes that clearly plain. And then if it doesn't, maybe we can suggest some language that's less ambiguous. And it may be there and we just hadn't looked at it, but it sounds like people are maybe missing that if it is there. So. Yeah. That's a homework assignment. So a couple more things, and then we are done for tonight. There are 3 pieces of legislation that have been put on hold, waiting for this process to play its way out, and I appreciate those council members entrusting us with that. And they are, I think y'all have copies of at least 2 of those. One of them is the proposed parking requirement, and that is coming back, I have this written down, in March, I believe, and then there was a proposed STRP overlay, which is coming back in May. So that's BL 2021-831 and BL 2020-504. They look like this. We're not going to deal with those tonight, but again, part of your homework is to look at those. I know that we've gotten feedback on some of those. There are people who love them and people who don't love them. And so our charge, again, is to try to make all this stuff happen simultaneously. So either we say these are great, we'll just try to pass them all at the same time, or we can do better. We can figure out another way to deal with this parking issue and come up with what that is. So if y'all will look at those bills. There's a third bill that has not been filed, but I believe Councilmember Sledge is considering it. Yes,
Mary.
Marilyn.
Which one? I don't have that cut sheet. Which bills?
The bill numbers are BL 2021-831. I think you're getting a copy, and BL 2020-504.
Thank you.
Coming at you. Thank you. somewhere in the move from Division 17 to Division 6, we lost a distance requirement. And in fact, we actually have a bill on public hearing this Tuesday referring to something that's not there. Joey.
I just received something today from Metro Legal regarding that. Legal opinion from Metro Legal today for us. I think I messed up our mics.
Thank you. So the issue at hand is that, if I understand it correctly, that statement doesn't exist in the Metro Code right now. And so the question to this group is, there was a requirement that non-owner occupied be 100 feet away from churches, daycares, schools, and a couple of other things, similar to bars and liquor stores and things like that. It got lost in the shuffle. Councilmember Sledge would like to put it back in. So again, just ponder that one.
I thought that it did pass.
It did pass.
But the amendment to it said that the master deed to that property had to, if it was after September of 2020, that it could not be within 100 feet of a park, school, or church or whatever. But anything that was deeded before September 2020 was still okay, because it was going to affect all these property, like the 505 and like anything that was in close proximity. I mean, you can't throw a stone without hitting a church. So I think that's where that one, right? Or did it not?
I think it passed, and we had that discussion.
Yeah.
After that, we made a change. I think this is the sequence. We moved everything from Division 17 to Division 16, and that hadn't been incorporated in because the Muni Code, the company that codifies our bills, does it on a couple of month basis or whatever. Somehow that language got left behind. So if you look at our code today, that language that was passed is gone. And that, I think that's a mistake, but I think to get it back in, we have to repass a bill. And so, whoops, that's one more bill
that
that
a lot
maybe
of opposition. I feel like it went through the ringer, and
It
then that's
did.
where it ended up. Gosh.
It did, but and I mean, the lawyers in the room can tell us. I mean, it's not in the code today, and I don't know if we can administratively say it was passed and it should just automatically move to Section 6, or if it has to go through another legislative process. So if you can answer that question real quick, then we'll talk about what our homework is on that one. That's a Metro Legal. Okay, so our homework will be to check with Metro Legal on that. I'll do that one. And then for folks to ponder.
I'm sorry, can you remind me of that's Colby Sledge's bill, right?
That was Colby Sledge's bill. It was passed several years ago.
Do we remember the caption?
Bill number? I have it written down.
Okay. If you can share that with us, that'd be great.
I think it was passed in 2020.
Yeah,
That
the
sounds right.
the first bill number I've got is 2019-78. That was the 100-foot separation bill. And then,
Okay, that's it.
And then Bill 2021-87 is where it moved from Chapter 6 from 17. So those, the amendment came, but the section that it was amending was already moved to Chapter 6. So I think that's the issue.
That's how we lost it.
Mm-hmm.
So, I mean, just a technical glitch. And so the question is, Councilmember Sledge would like to bring that back. If it comes back, it would be better if it comes back as part of this package as opposed to having another thing. I think this group is doing a good job of looking at the big picture. That's just something we need to consider and have some thoughts on at our next meeting. And I will say, when we are done, we can't presume that we represent the world. So this will then have to go on a neighborhood road show and go to some of the industry groups and hopefully tell them that we've done this thoughtfully, and hopefully they'll say, y'all are geniuses, you're good to go. It's possible it doesn't go that way. But I mean, I would love for this group to try to come up with stuff that we think that both viewpoints will be comfortable with. So these are kind of the thorny ones that are going to be trickier. So that being said, I think we are through with our business for tonight. I appreciate the good discussion. I do think we probably need to meet one more time, maybe 2 more times, to finalize whatever legislation we're going to do. So I think our goals for next meeting are, Joey, if you can finalize the things that we've talked about that are already written. We're going to have the template edited by our team of 3, and I'm going to check with legal on, just to be sure, on the distance bill, that we know where that landed and what that process would look like, and if we want to overtake it. And then everyone is going to look at those 3 bills, 2 of which you have here, and the other one doesn't exist, but you can go back and look at BL 2019-78. Was that the number, Joey? That's the distance one. Okay, 2019-78. Yes, ma'am.
This is specifically kind of relating to the parking bill, but in the information that you all mailed out that shows the complaint distribution over time, do we know what time frame that falls within? Because it just says total calls of all time. And then if we look at trash complaints, we can see there's been 401, or sorry, not trash, parking. There's been 158. So I'm just interested to see, related to the parking bill, what time frame that was that the 158 have happened over.
If that says ever, does that begin in 2014 or whenever the first legislation passed?
No, it begins with the contract with host compliance. Approximately 4 years.
So that, yeah, about 4 years.
Okay.
Good question.
And this does say that it doesn't include any complaints through hub, email, phone, inspector reported, or other means.
Those are complaints only through host compliance.
Right.
Is what you're referring to. Is there a way to find out if there are complaints through hub?
I would have to see if ITS compiles that information. I don't know.
Could you look into that? More
Yes,
homework. Sorry. Okay. I think that's a good question. I think that's something we need to be aware of. And I would also like to provide the parking table that shows all the exceptions to the parking requirements, because I think that's useful information to know. When it says you have to have the proposed parking bill says there needs to be, like a hotel, 1 parking spot per room, which can be challenging under certain circumstances, but we know that parking is one of the things that we do get complaints on. But then within the parking table that requires that, it also says, but you can do shared. If you're in the urban zoning overlay, there's a reduction. So I just want people to be aware of that. So I'll try to provide that ahead of time as well. So that is also a homework assignment. I'm going to write that down, parking table. Okay, so that's our homework for the next meeting. And I think our goals for the next meeting, I'll throw out and then I'll accept comments, would possibly be to review one last time the ownership document, the legislation that's already been proposed, and then to discuss how to deal with the proposed bills that are hanging out there loose. And if the stars align and we get done with that conversation, then those will all try to be possibly incorporated into a single one, or at least to talk through the timing so that they all land at the same time. And then we can decide if we're done or if we need to meet again, and then we can organize the neighborhood roadshow, because that's important as well. Does that seem like a good goal for the next meeting? Yeah, good. And do we want to stick with, I mean, right now, if we meet another 2 weeks from now, does that seem like a good schedule? And does that bump us into another short-term rental appeal meeting, or do y'all just meet once a month? Okay. So does 2 weeks seem like a good time to start talking about?
I'm not available, but that doesn't mean that we can't schedule a meeting.
How many people would, let's see, so that'll be the February 9th. I have that on. Okay. Does that work for most people? Obviously, it's hard to catch everybody. Okay. I think we have 2 Nastra, so as long as one of y'all can be here, if that day works, and we got a couple of neighbors.
I'm here for District 6, so I'll get somebody to.
You're District 6. Okay, cool. That sounds great. All right. Any other questions or thoughts or comments? Okay, I appreciate everyone participating. I feel like this is a good discussion, and we're getting some good things done. So I'm going to adjourn this, and we'll be here, same place, 2 weeks from now, 6 o'clock. And everybody do your homework. I'll send out notes again. Thank you so much.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.